Right. So we have discussed about the directors, their appointment, their removal, their qualification. And today, yes, we discuss about the duties of directors and secretaries and auditors in the morning. And in the afternoon, probably we can discuss about the winding up. This will recap what we have done last week or 2 weeks before. How to appoint permanent directors. Yes. Passing resolution. Passing resolution to Malakan Study. So basically, we have said appointment of directors are there are 2 types of appointment: initial appointment and the subsequent appointment. Initial directors are not appointed by anyone. Right? The person whose names are in the application form automatically become the initial directors of the company. And then they have to resign at the first AG. Then thereafter, all the subsequent directors are appointed at meetings, passing resolutions all for that purpose. Appointed by shareholders, passing only resolutions for at meetings. That's the after that I okay. Resolution to resolution by shareholders at resolution passing only resolutions for that. Right. Today we discuss about the director's duty. Director's duty. So this is also important part of company law. One reason that it is important is until 2007, director's duties were not written, not carried. It is in 2007 that in Sri Lanka we have a proper written director's duty. Before 2007, there were complaints, there were duties, but those duties to be identified by looking at the English common. So because Sri Lankan company law based on the English common law. So in our act, no director's duties were written. So whenever there's a breach of duties or whatever, our directors, so our company lawyers have to look at the English common. So you can see for the general people how hard it is. Right, to refer English judgment and check what are the duties and so on. Right. So therefore, it is important. First time in Sri Lanka from 2007. Now directors' duties are cataloged. So they are clear. Now before becoming a director, now you know what type of duties expected from you. But still there are some issues here. We as an example, the act set out the duties but not liabilities. Right. Therefore, if they have breached or broken their duties, sometimes it is not clear what to do. The company can take action like the company can expel them, right? Remove them, right? Or sometimes they are clear, but in many occasions it is not clear because there are no person about the liabilities of directors whenever there is a breach of their duty. So that is one issue. I think to address that issue in UK now they have passed the Directors' Liability Act. Right? Apart from the companies act set out the duties of directors, they have passed separate act about the liability of directors. That will set out what we'll do, what are the punishments, what are the remedies when there's a breach of directors' duties. Therefore, that is to be addressed in Sri Lanka, but however, at least the act set out the directors' duties, and I hope that if those company directors are aware of their duties expected by law, no one will be happy to be a director of the company. Right? Because it is sometimes some people say it's too much. Right? As a result, some countries like New Zealand, Singapore, right, really hard to fight the company director. They don't want to get that risk. Right? because there are some cases where directors are even imprisoned for breach of their duty. And also in every year, sometimes in countries like Singapore, they have a workshop of other directors. So those are the duties that we expect from you and so on. Therefore, even in Sri Lanka, you know what happened in the EPI, what happened in the Golden Key, right? So directors are definitely liable. But as we do not have a liability act, even though companies bankrupt, even the Prabhupada bank cases still they are not paid, but still directors are, they go in here and they are paid, right? So as in Golden Key and the EPI asset, right? Therefore, they have a huge duties expected from law. If they comply, they know their duties, at least I'm sure that we can really minimize that type of issue. So we see now almost all those common law duties, which were recognized by the common law before 2007, now are written. Right? So therefore, now they are known as the statutory duties. Those statutory duties are the common law duties that were recognized before 2007. And also law says, these statutory duties are there, but still English common law duties are also part of our company. Therefore, whenever there is no duties recognized by the Act, that common law duty is still a part of Sri Lankan company. Right? Now we'll see what are those duties expected from director. Right? So now you don't need to write like you did in the error that director's duties are to attend meetings, not to make secret capital. You don't need to write it that way, right? They are correct according to the company law or the common law, but they are very clear. Right? As an example, when you discuss the director's duties today, we don't need to say that it's a duty of the directors to attend the meeting, because it is in fact it's their responsibility to attend the meeting. Right? When you go through the director's duties, we understand. Even though, say, as an example, one company has 10 meetings, a director has participated all the 10 meetings, but in all the 10 meetings, he went astray, passed astray. So according to this law now, he has not done nothing, because his duty is to not to be reckless, not to be negligent, right? To use his due care. Those are the duties. Coming to the company meeting and to pass astray is not performing their duties at all. Therefore, it is not the duty of the directors, right? So their duties are much more complex than that. Attending the meeting. So therefore, this is one of the main duty expected from our directors. So this is also English common law duty. Now it is written, right? So duty of directors to act in good faith and in the interest of the company as well. The duty of directors to act in good faith and in the interest of the company. If you look at the section 187, it is there in detail. Right? So we have to at least some you may be directors of a company one day. At least your own company as well. Right? That's the downstairs. So it says the person exercising powers of performing duties as a director of a company shall act in good faith. Right? Shall act in good faith and in what that person believe to be in the interest of the company. Right? So terms are important, right? What that person believe to be in the interest of the company. Therefore, not what you think, not what auditor think, not what judge think, but that person, that director think, believes to be in the interest of the company, because law believes that directors are business people. So they have that knowledge, not judges, not auditors, not anyone else. Next. So what that person believes to be in the interest of the company, so he should act in that way. Right? But they will say, business people. So in our country, there are issues whether there are business people as board of directors. That is something else. But it is intended to be from the business who has a good knowledge of business. So what they believe to be in the interest of the company, so that is what they should. But it will say what that person believes to be the interest of the company. So then he can act according to his wish. They have that knowledge. But there are some issues. What is meant by company? in the interest of the company. Does it mean shareholders or more than? Okay, but the company has a whole here. In the company as this. What will be? So the interest have the debate for the interest of the company. What is meant by the company? Does it mean shareholders or does it extend more than that? How do you think it will be done? This is a never-ending problem with company, right? Because there's a one argument that directors are there to maximize the profit for the shareholder, right? Shareholders for agency application. So there's another theory that no, they have a social responsibility act. Under that, it does not give to the shareholder. Therefore, it in fact depends on the nature of each case. There are some few cases they have decided company means shareholders. Shareholders means all the shareholders of the company, right? But there are some other cases they decided that no, that definitely include the creditors, right? Because as we already know, especially cases are there when the companies are in the bankrupt situation, right? In the bankrupt company, in fact, owners are who? Creditors, right? So therefore, there are some other cases where they have decided directors definitely have a responsibility for the creditors. There are some other cases they also believe not only the creditors, but their employees and all other stakeholders as well. Recently, there was a case they decided even a winding up company has a responsibility towards the clean the environment of the company. And they have responsibility even for the environment as well. Wind up taking care of it. Wind up company responsibility got funds resolution. Likewise, now it is really wide. So now what is basically meaning is Islamite? Yeah, they expect because access company, right, in the interest of the company, but company means sometimes it is a shareholders, but court has decided company include all the stakeholders. Yes, directors duties towards the company, but company include all the shareholders. Definitely include the shareholders, creditors, and other stakeholders. Therefore, their duty extend towards all other things. But that depends on the situation, right? My situation again, I'm not responsible for that. Where will it take? Right? Sometimes there are cases where you have to take action. In that case, court will decide accordingly. But definitely, yes, as a whole, they have a duty to act in good faith for the interest of the company. Company does not limit to a shareholder. According to that case, okay? Maybe creditors, maybe shareholders, maybe environment, right? So definitely not majority shareholders. Definitely not minor shareholders. Definitely not part of shareholders. Company as a whole, and that includes all the shareholders plus all other stakeholders according to the merit of that case. So he has a duty to act in good faith of a company where he is a director. For the interest of the company where he is a director. Now what will happen? I also had this question one day. Say now there is a company. A company acquires B company, so B company is a fully owned subsidiary of A, right? B company is a fully owned subsidiary of A. Now A appoints one of its director X as a director of B company to safeguard their interests, right? So B is a fully owned subsidiary of A. A appoints X as a director of B company to safeguard their interests. Now, according to the general law, X should act for the betterment of which company? A company or B company? Like X act करना है, A company rather B company rather. According to the law, it is clear. They have to act in good faith for the betterment of the company where they are not. එහෙනම් B company තමයි කරන්න ඕනේ. හැබැයි මේ වගේ එකක practical. X will act for who? Definitely X in this case will act for the betterment of the A company. So that is also recognized by the act. Right? If you look at a section 187 provision, right, you can identify that theory as right? But a practical is acceptable. But the 16. Object of a company which is only one subsidiary of the company may, if expressly permitted to do so by the company's actors, act in a manner which he believes is in the interest of that other company, even though it may not be in the interest of the company of which he is an agent. That practical situation is also accepted. But remember, it only applies when that company is a fully owned company. If only you have 75%, 51%, that will not happen. It only applies if it is a fully owned company. As now practical එකක් තමයි මේ අපි කොහෙකින් මගේ client කෙනෙක්ගේ private company එකක් තමයි අපිට කරන්නේ. ඒකේ අන්තිමට 60% ගත්තා අරගෙන කොටකට. later board එකක් ඒකට apply කරලා අපි ආල් ප්‍රශ්නක් තිබුණා. අපි කොහෙක හැම්පිස්සර ඒ ඉන්ට්‍රස්ට්ලා ඒගොල්ලන් කරලා ගන්න. Council according to the they can't do because it's not a fully owned company. They have act for the betterment of that stock, not according to the office company. They have acted in good faith for the company where they are. Only exception is if it's a fully owned company, then they can act for the betterment of the office. Otherwise, they have to act for the betterment of the other company. Under the good faith concept, to act in good faith concept, it also includes directors have a duty to use their power authority for proper purpose only. This is known as the proper purpose doctrine. So the good example in this case, we might have discussed it before as well. In this case, what happened was, fortunately, the person had contributor. What happened in this case was there was a say two companies, A company and B company. A company wanted to take over B company. Right? So directors of A company wanted to take over B company. But for that they had to pass a resolution. Majority shareholders were against the takeover bid. Now they can pass the resolution and make a takeover bid a success. But minority shareholders were in favor of the board. Then what they did was the directors issued large number of shares to the minority shareholders. Then minority became majority. Then they pass a resolution. Then they made the takeover bid the success. Thereafter, now minority, before the share issue, majority filed a case. The argument was to cancel the share issue because it was not done in good faith. So what do you think? Now you know, we discuss about the issue of shares and all. Who have the power authority to issue shares? Board. The board has the authority to issue shares. The shareholders have nothing to say. Right? It is the power and authority of the board to issue shares. But it doesn't mean that they can issue shares as they wish. They are subject to some section of the company act. Right? As an example, there are preemptive rights. Right? So that means if the new shares rank equal or above the existing shares, then they should be made available for the existing shareholder. And also when issue shares, they have duty to decide the consideration, but it should be fair. It should be just and fair for the company and existing shareholder. So subject to that, they can issue shares. And also there's another provision that they have to act in good faith. Right? Subject to those provisions, the directors can issue shares. So here they challenge that they have not done it in good faith. Right? So even in this case, the court decided it is true that the board has the power to issue shares. Right? So that power is given to the board by the law to issue shares to raise the funds whenever necessary. Right? If they have used their power to raise the funds, then no one can challenge it. But in this case, the court was of the opinion that here board have issued shares not to raise the funds to the company, but to dilute the voting power. Right? So they have issued shares to dilute the voting power, not to raise the company fund. Therefore, court was of the opinion that they have used their power authority for improper purpose. If you use your power for any other reason which is not given to you, then it is an improper use of your power. So court decided that also include act outside your good faith. So they have not acted in good faith, right? So improper purpose you can't use, right? So it is known as the proper purpose doctrine. Right? If you don't act within your power, then you have not acted in good faith. So court decided they have broken their duties and court declared that the share issue was invalid and share issue was cancelled. In fact, තමන්ට බලයක් තියෙන එකක් උනත් එහෙම කරන්න බෑ. මේ නීතියට අනුව තමයි කරන්නේ. Within power. But this is another duty to expect from the directors today under section 118. So directors' duty to comply with the Companies Act and the Articles of Association. So we already know now, directors have very wide powers, and there is no law that board has to follow or board has to act according to the wish of the shareholders. There's no such thing. Even though they are not bound to follow the wish of the shareholders, they are bound to act within the Companies Act and the Articles of Association. So if they do not comply with the Companies Act and the Articles of Association, then it is a breach of their duty. Then a shareholder or company can sue against the board. Right? And also, if you remember, you can get the test training on. Test training on. Now, company is formed to sell chocolate. That means the company's article says the objective of the company is to sell chocolate and so on. Now, this company says choose. So you are investor of this company, you have 10% share. What actions you can do? You are strongly against the shoe business. So you believe that company never will make profits by this business. Therefore, you are strongly against this new business. So what actions can you get against the company or directors? What is in front of you, right? If the article says that the company is formed to sell chocolate, the directors have a duty to comply with the articles. Then they should sell You're correct. Right? If they do something else, right, it is the contradiction of the articles. Right? So they have broken their duty. So you can sue against the directors under Section 188 for breach of their duties. So if the articles say something, then they have a duty to act according to the articles. So you can sue against the directors for breach of their duties. Okay, alpha virus against attack. So if there is objective, then directors have a duty to act within that objective. The company is fine. There's nothing you can sue against the company, but you can sue against the director for breach of their duty. Then say now directors have done it by passing a special resolution. Then hopefully they can justify it. Because it's a major transaction massive to change the nature of business. So therefore, directors have done it in the proper way by passing a special resolution. Now what you can do? But still you have voted against the special resolution because you are strongly against. Now what you can do? Then what the directors are on the say, oh, another example, the directors have already started the shoe business. Then you can't get the trust training orders. This is but if they have already started, then what will not order against the company. Now they have started new business, they have passed a special resolution, but you have voted against the special resolution. Now what you can do? You are 10%, 90% in favor of shoe business. But you are still against. What you can do? You are going to help you, you are mindful. Which 10% is mindful. What you can do? You are against the special resolution. Still there are remedies for the minority shareholder. Right? If you remember, minority buyout rights. You have a right under Section 93 to request from the company to buy your own shares. Then you can ask the company to buy your 10% asset, and then you can go out from the company for a reasonable price. When there's such a request, the company has a duty to buy your shares for the market price. Right? Then you can go out of the business with a reasonable price, and you can invest in the company where your interest are. So even in such a case, there are provisions on the companies. Minority buyout rights. So minority buyout rights are there for the minority shareholders who have voted against the special resolution. Section 96. This is another important common law duty. Now it is also statutory duty. Directors' standard of care. Directors' standard of care. Right. It's also very important duty. Right. So it says a person exercising powers or performing duties as director of a company should not act in a manner which is reckless or grossly negligent. So when they act as a board or director, they cannot be reckless or negligent. As an example, they can say, I signed the blank check and I've given that authority to the finance director and so on. So you can't say. If you sign a check, you are responsible. You can say you have given that power to someone else. That's a board you are having. Right? To sign blank check clearly says you are reckless or negligent. No excuses, right? So therefore, these are reckless negligent act, right? Sometimes there are directors, as I told you before, they come for all the meetings and all, but from the very beginning, maybe 10 minutes they are there until they are served the fee and so, right? Once they had the refreshment, they pass the fee, right? So whenever there are resolution, yes. Right. We don't know what it is. Right? So however later it was revealed that he had no knowledge of that resolution. That shows their reckless, negligent act. Right? So those directors may be liable for their reckless, negligent act. That they have voted for a solution that they have no knowledge of. So that is not what law expects from the directors. Right? Therefore, they amount to signing blank checks, right? Voting for the resolutions they have no knowledge of, right? So those are reckless, negligent acts that directors may be liable, right? Oh, and also they should exercise the degree of skill and care that may be reasonably be expected from a person of his knowledge and experience. Right? So some people, some countries say these are too much for the directors, right? So they have skill, they have used their degree of skill and care that is expected from a person who has his knowledge and experience. Therefore, this is a burden for the professor. If there's an audit of the board, what law expects? Law expects skill and care of an auditor, a person of his knowledge and experience. Then you can't say, I don't know auditor, I don't know. Which way the board, right? If there's a lawyer in the board, then they can't say, I don't know the law, right? So therefore, if there are professionals in the board, the law expects more than the name from those professionals. So this is criticized in some countries because if you're going to expect that much of skill, care, reckless, negligence from the directors, it will be burden for them, and also you won't be able to find programs for the board of claim. Because there may be some auditors, lawyers, they don't have knowledge in every field of law and audit. Right? But when there are issues, if they should take responsibility, so you won't find it. Right? That is why I said in some countries it is hard to find directors to the board. I think now Australia have taken new step. So they now have some new step. They say if a person is selected to the board because of your profession, then law expect that knowledge and experience. But even though you are a professional, but you are not selected to the board because of your profession, then what is expected is again the skill and care expected from the general layer. Right? So that is how they modify that topic. Right? So our board data auditor කෙනෙක්ගේ බලාපොරොත්තු වෙන ස්කිල් එකක් නේ. හැබැයි auditor කෙනෙක්. හැබැයි board data ගන්න auditor කෙනෙක් කියලා නෙවෙයි. You are appointed just as other person. Then what is expected is what law expected from a general person. So in that way they have relaxed law to some extent because otherwise some people they don't want to be a directors of the board. Right? Because they are also human beings. Right? Under this section, it doesn't mean that they have to keep their eyes on 24 hours on the company. But what law expects is what is expected from a reasonable person. Reasonable person. Can directors or board rely on information, people's statements, data given by other parties, experts? Can they get such information and can they rely on it? Can they use those information and advice from others, board of directors? Directors are not expert in everything. Right? They can, but only according to law. Only according to section 19. Advice, consultation, but not because of your husband is in that consulting. Right? Because you really need such information. Therefore, the law says how to get advice and information from other parties. So you can get that information, but only according to this section. This is how they can take advice and information from outsiders, experts, right? In good faith. But after what again, right? Husband, partner, consulting because some companies pay billions for consultants, right? So they have to act in good faith. Makes a proper inquiry where the need for inquiry is indicated by the circumstances, right? So there is a real need of such expert evidence, expert information. And has no knowledge that the results are unwarranted, right? Then only they can take that advice from others. Board के कवर इन्वान ये करता है क्या करता है? There's a proper real need for such information. Right? Then they can rely on that information, they can take that advice, again provided that board has acted in good faith. So then only they can get such information. We have done, there's a real need of such information, but company ignore it. Say now you have a company, you're going to start a company in the port city. Dealing as finance department, finance team of but you need some expert advice, but they expect say high amount, therefore you ignore it. You decided what to do, even though you had no knowledge. What is that? What is the yes? What do you think about the vision of the board? Not to go for expert advice. You think that or not acted in good faith, that's so much. But you did take that. To take advice which are irrelevant and unnecessary is a breach of your duty. අනවශ්‍ය දේවල් ගන්නවා නම් ඒකත් කරන්න. අවශ්‍ය දේවල් ගන්න නැත්නම් ඒකත් කරන්න. right? It's come from that නේ. අපෝ මෙතන යන්න. right? අවශ්‍ය දේවල් ගත්තේ නැත්නම් ඒක it may be reckless or negligent act. They have not used their due care and diligence. right? But අනවශ්‍ය දේවල් ගන්න එකත් වැරද්දක්. අවශ්‍ය දේවල් ගන්න නැති එකත් වැරද්දක්. right? So breach of the duty. ඒක ගත්තේ නැත්නම් මේ තමන් දන්නේ නැත්නම් so then it may be a breach of section 189. Right? If you get advice which are not necessary, may be a breach of section 190. Lanka is a case now, picture of the case. So this claim says the provisions contained in this act are in addition to and not in derogation of any provisions contained in any other law relating to the duty or liability of directors of the subject. Therefore, clearly, English common law is also a part of Sri Lankan company law relating to the duties of the directors. Because they have very developed law, they are also part of Sri Lankan. So there are some other relevant section as said about the director's duties. So section 191, 2, 3, 4 says about the transaction where the director is interested. So we all know that directors are separate, companies separate. Therefore, there's no restriction that they can't do business with the company. They can be a shareholder, can be a creditor, can be a supplier, right? So they can do business with the company, but they have duties. Mainly, they have a duty to disclose. They have a duty to write them in the interest register. Right? So, provided that they follow those requirement, then they can do business with the company. But their duty is to disclose them and to follow other requirements of the Company Act, like write them in the information. Can directors use the company information for their personal gain? Section 197 says, as a board, there are some sensitive information are available for the board, but they cannot use them for improper purpose. Can a director of one company be a director of another company? They can. First and approval. Can a director of a rival company become a director of another company? Anybody can do that. Monkey can do it. That's no lower than a restriction. Particular when can that. Loki over here and a rival company in the some other I'll say that you want to find one. Rival company here, then I'll take particularly can that. But the law is that they can't use that information for gain of other. Take it on right? If you speak the protector one, there's no issue in law. Right? So, yes. They cannot use the company information for personal gain. In this case, IDC versus Cooley. Cooley was a consultant, right? IDC, Industrial Development Company, whatever, they provided the consultancy services for the gas companies in the area. Cooley was an expert. Because of his expertise, this company had so many demand, very huge demand. So whenever there's a huge demand, you know what happened? They charge more money, right? So as a result, there were so many clients for this company. There was one negotiation where one company wanted Cooley, that means IDC, as their consultant. Cooley was the managing director of that company. So in the board, they discussed about the prices. Cooley was also there in the board. Right? The company expect huge amount. Cooley knew the amount, right? So therefore, following day, Cooley resigned from the company, and next week he was a consultant of that other company. Then his previous company filed a case against him for breach of director's duties. Right? There were two allegations that he had not acted with good faith and he had used the company information for personal gain. So what do you think? In this case, the High Court decided he knew the price amount because he was in the board that discussed about the price. That is only available for the board of directors. If he was not a member of the board, he doesn't know what is the amount expected. Therefore, court decided he has used the company information for his personal gain. It's a breach of duty and ordered that amount repaid to the company. Right? Therefore, they can use their personal gain for improper purpose. How if he was resigned before this contract? That should be okay. Ne? Then he was not in the board. Ne? Someone person of knowing the thing. Right. Before ending the director's duties, I want you to read these two sections as like 219 and 226. To me, they are such a very important duties expected from a board. But I don't know how many directors are out there. Right. Section 219, duty of directors on insolvency. Duty of directors on insolvency. Lanka and resources winding up here, not about the PhDs. They are discussing on the media, but I know there are hundreds of more countries are Lanka. They are not discussed by the media. They are not sent of the media. Finally, I'm going to affect the law. It used to limit constructed ஒரு பாராட்டுதல் அப்படி காத்துக்கிறாரு ಸಂಪಾದನೆ But every bank was at least given this time. Because of the discussion of this kind of common court development separate, let me say. They can argue that part execution can have better part. The money for protest that. They don't tell you for protest. One year I want to develop the young people. I don't pass on over it. They got enough money. Protest stuff in it. Eat money, I don't think that I got enough bank of protest of booking book there. Now that they are booking again, pass them booking girl, but they have profit net. Allowing the material to go on. They give them book and not there. Never found that not something not a six months. We did it from that. Posted worry from that. Now, if you know that, what they are not doing, what they are not doing, especially by food. One day that you know, some of those over the negative side, like at least now, car made 18%. Right? Life business car and the mother. Do not come up with that again. That's the work was very good. We have to back to car loan raising on this. Business car loan they have taken. Right. Then UK will have one making a figure and the someone in the country feeling that that's 30% for the people. Petrol, cigarette, calendar, and it's never equal 30% for it. That's how we do it. Lanka will be so much powerful, but they will have three goals. If you tell us that you pass the use to bury that way, we don't kill a summer. If you will be a nickel after a factor that you can like the problem. How can I do it? You are like the if I give off equivalent of the Lava in this Valada. So, how we can do it? You don't get up, take it after today. Public process, whether they are the answer to Lava. If I give the details, I can't make 3 over. Then we won't put it. There's no idea that a clear is not there. Right. No, when they are there, they are just speaking. I get on time, other than the own thing. The father and the thing, I want to keep the idea. He out the mana, you pull the English video. And that's like you be able to people. අද කැම්පස් වල ඉංග්‍රීසි මීඩියම් කෝස් වල නේද? ටීචර් ට්‍රේනින් ස්කූල්ස් නේ ඒව එකද කරන්නේ. මේක පටන් ගන්න එපා අද පාරේ නැත්නම් ඔක්කොම ඉංග්‍රීසි මීඩියම් එක. ඊට පස්සේ ඒලා කිසිත් කරනවා. ඒ වගේ කිසිත් කරගෙන කියනවා. විභාගයක් තියාගෙන ඉපැයි. ඒ වගේ තියාගෙන ඉපැයි කියලා. ආයෙ නඳුවන්නේ. ආයෙ නඳුවලා දැල්සක් මොනවා කරන්නේ කියලා. දැල්වලට කායසන්නේ. නාටි. මම කැම්පස් එකේ ඉන්නේ. ජනවාරි වල කපල් ගන්න. අපේ දැන් දෙසැම්බර් වල පටන් ගන්න මාතෘකාවක දාලා ළමයි ඉංග්‍රීසි මේ දීලා නැත්නම් 2023 ඉන්නේ නැහැ තරනේ 2022 ළමයි ඔය 2022 අගෝස්තු ළමයි එක්සෑම් දෙන්නේ 2022 නේ ඉතින් 2021 ඒරෝතල ලාභෝ 2023 ජනවාරි වල උඩ ගන්න අපරාධ දේවල් ඔය 2023 එක්සෑම් එකේ 2022 අගෝස්තු ඒ ළමයි දැන් කැම්පස් වල ගන්න පුළුවන් UGC දඬුවම් ගන්න. මේක 2023 අගෝස්තු කරේකෝ 2023 අගෝස්තු තුලා 2022 අගෝස්තු තුලා මම අවුරුදු එකමාරදී මම හිතන්නේ දීර්ඝ කතාවක් කරනවත් නැත්නම් කාටද තමයි. නේද? කාටවත් ගන්න. right? කල්යනම් ගන්න UGC එකේ කිව්වොත් ඒක ගෑනවා නේද? අර පිළිගන්නවා තමයි. ගම්වල කොළඹ වුණාම මම හරි කරනවා නේ. ඒක ඉතින් හරි අපරාධයක්. බලන්න හොඳට නම් තේරෙන්න වෙනවා. අනිත් බලන්න නියුවර් කරගෙන මම ඕනේ බලන්න. ඉතින් ගෑගන්න සාධාරණ කියන තුන පරිස් කරන්න කිව්වොත්. ඒක මම කරන්නේ නම. දැන් කරනවා. ඒක නම් බාහිර ගන්න යනවා. කියනකොට ඔය ඇත්තටම හිතනකොට වෙන්නේ කියලා තමයි. Kalau mau buat proses apa ini? Jadi berarti boleh keluar untuk iya teknik ada buat proses tangan itu. Sama di stres itu ada di sini. Ya kata anda kalau ini siapa sih yang itu paling oke? Dia nanti bisa pandangan energi mana sudah tahu. Karena itu lagi kita tahu. Ini ahli kita capture kan nih. ඒක කියලා පොරොත්තු කල්ලි තියෙනවා අපේ ඉදිරි සැලෙන්නේ මොකද පොරොත්තු කරලා මොනවද අර ටෙක්නොලොජි පැකේජ් එකේ ගානේ හරි කායම තා පොරොත්තු ආවත්කම් කරනවා නම් මම දැන් මේ කියන්නේ දීපස්ම පයිලට් එක කසලා පුසුපත් ඒක මේ අපේ අපි ඩිස්කස් කරන්නේ කැම්පස් එකේ නම මොනවද කියන්නේ ඩිස්කස් අන්තිමට ළමයි නැති වුණාට ප්‍රමාණ කටයුතු තියෙනවා. කැම්පස් වල ගොඩාක් නෑ අවුත්. අමාරු මොනවද හොස්ටල් වල එනවා. මේ වීඩියෝ එකක් කොහොමද නැහැ ගහලා එනවා කොහොමද? එමෙලක් වෙනවා ඒ හොස්ටල් වල හොඳ පැත්තක් තියෙනවා. කොහොමද මේ මිලිටරි පැත්තේ වල එකක් අපිට මේ BS එකේ BS 9 ඉඳලා ගන්න. දැන් ගන්න දීලා. ඒකයි. මොකද කැම්පස් වල first exam pasala maka derna plus agak oke health person sih lama yang berita nih dia orang yang berita mana nih itu dari kata dia dia berita di kampus ini aja terus ini kayak gini dan masih tema ya Allah kita nama beliau seperti di luar dari lapangan ini malah bahasa langsung. Yang kita waktu itu, amal untuk film mana sih itu. Jadi kami di pasal juga pernah tahu ini. Kita nanti kita kita tahu pasti akan bisa untuk berhidup ya. Saat itu mah kulit kayak mana. Dan bilang yang dari film orang-orang bahasa berkata itu Jadi itu baru teman-teman yang penting dalam hal ini ambil itu. Kalau di pas hari itu ya, terus Yesus, kami kamu dan apa? You can't find a solution. Right? The more I'll pay, so how do you punish them? What do we have to do? Colombo hostel level, this year it was to be there. On the middle of the shop, they get the break out of the back of the time, but to Matra is this year, I cannot watch to my to be over for even to do it depending. But there is no care and no regular that. So the industry will not spend it. Fine. Look at section 219. Directors mutual insolvency. Just let me know how that section starts. Start anyone again? Yes, the director of the company who believes that the company cannot pay its debts as they fall due. Right? I really wanted you to look at that section now. It's a director of the company who believes that. Because directors are business people, right? They don't need the certificate from the auditors and so many courts and so and so on. If the directors believe that the company cannot pay its debts as they fall due, then they have a duty to call a board meeting. Right? One director can say business knowledge is smart. If the directors believe that the company cannot pay its debts as they fall due, then they have a duty to call a board meeting. At that board meeting, they have to decide whether to carry on, whether to wind up, or whether to appoint an administrator. So if those things are aware by the directors, hopefully those things should not be happening. Golden key case, API case should not be happening. Right? If they know their duties, right? If they believe that the company cannot pay this as they fall due, then they should immediately call a board meeting. At that board meeting, they have to decide whether to carry on, whether to wind up, or whether to appoint an administrator. If the board decided to carry on, if it turns worse, then those directors who decided to carry on are black. Right? Up to early stage. 220. Serious loss of capital. If that any times it appears to a director, right? If that any times it appears to a director that the company is in a serious loss of capital, then the board has a duty to call the EGA. One of the directors are the appears, may penny. Loku Bala Padwati, Loku serious loss of capital again, accessory by Adu, right? Then they have a duty to call the EGA. But dates it should be called within 40 days and held within 20 days. Right? Right? And then they have to disclose to the shareholders what is the extent, what is the reasons as they know, and what steps they have taken. Right? I don't think any of the company directors are aware of those sections and they do them. Right? Well, one thing happened, the auditors again, if it appears, right? If they are in the opinion that, right, so they should take action and act accordingly. Unfortunately, what is important is, even though there are duties, the law is not clear if they ignore it, what are the liabilities? Right? That is not clear in our law. However, it doesn't mean that they cannot be sued, they can be sued, and it is up to the court to take action. Right? The court can decide something clearly, company can remove them from the post of director. And also, court can make orders as court thinks fit. But unfortunately, the one thing is directors are not aware of those type of duties. I'm sure they are not. Right? At least not duty. So here, right? That is why when you are director, at least the company also has a duty to send a copy of the director's duties. Even they can charge it, ne? Politically reproduce kara denna puluwan on singalunuth tiyena devanuth tiyena ne. Kewat natha denna puluwan. Adu gannewa thama duties expected from directors, right? So not only the PLCs but hundreds of private limiteds are also backed up. So that duties are not only for the PLCs, almost all the type of directors. Right. So if the directors are aware of those director duties, I'm sure we can minimize those issues in this. Right. Because it's the board, they have a responsibility to run the company and make sure that companies are financially healthy. Right. තමගේ decision ගන්න ඕනේ. සමහරවිට වෙලාවට මේ banks කියන ලංකාවේ banks තමක් මේ සම්බන්ධ සමාජයක් නේ. සමහරවිට මේ දොස් කියන්නේ මම එක කතා කරා සින්ස් බැංක් එකේ ආකිව්වේ දවසක් මේ you have to safeguard yourself. ඉස්සලා තමක් පරිසරෙ නයි දෙන්නේ නේ. ඒ පරිසුත් එහෙම තමයි. ඒක ලස්සන example එකක් දුන්නා when you apply in the site. So they give instruction. Take off the instruction. You know, in an emergency situation, how should we act? So, oxygen mask are not that all the way. Like when you have your son or daughter with you, right? This is the last year we are here. Yes. Someone doesn't take care of it, right? That is what husband was maybe. Putani is not someone coming down. Likewise, even the bad, they have to protect themselves first. Otherwise, they even cannot think of protecting the others. Right? Daruwa save කරලා හිතන්නත් බෑ තමන් save වෙලා ගත්තා නේ. ඒ වගේ තමයි බැංකුත් අපි even බැලුණා. They are also in a very serious situation. So they have to first protect themselves. Likewise, even the companies, they have to protect themselves and take action. Right, like for the corporate governance, even though this is yes, not under the topic, right? We can just have that's about 2-3 minutes about the corporate governance, right? So you know, corporate governance has become a subject in some discipline today. I hope do we have that subject, corporate governance? Good. It is subject in many management accounting today because now corporations are like government. Right? And they are more than the government, right? Because their turnover is really more than the GDP of many countries. Lanka, right? Some companies GDP even more than the India's GDP. Some companies turnover. Right? India that percentage is either somehow companies turnover. So they are clearly more than the government. And also in some companies, employees are more than some small countries' population. China and the other countries. Well, some other population is not very easy. Some business operates almost all the countries all over the world. As an example, Coca-Cola company, but they operate in almost all the countries except Cuba and Iran. So therefore, they are more than the government. Right? As we discussed on the very first day, we believe that we are governed by elected people. But truth is comes to people. Those elected people are governed by who? Controlled by who? Those elected people are controlled by the master class asset. That's the truth. Take a Lanka and Australia to find India. If there is budget proposal, we have to pay. They could research that and they control but they are controlled by the master transport. So sometimes we can accept that they can control the business, but it's very unthinkable. Those companies not only interfere in business, but they interfere in internal politics. Or maybe religion and sports. So that is why countries led by the UK initially. So they have proposed some of the guidelines for the corporate governance. So when we discuss about the corporate governance, directors' duties are major part of the corporate governance. When we come to corporate governance, it does not only include the directors, right? So corporate governance is all the responsible persons who are taking part of the corporate or company governance. So they definitely include the board. Apart from that, all other people who are part of the management, definitely auditors, second, CEOs, managers, they all are part of the corporate governance, not to the limit. Right? So corporate governance is a system with the companies are directed and controlling the human. So it's a system which makes sure that the companies are directed and controlling the human. Corporate governance ensures that those who are responsible for the government of the company will properly govern it. Directors' duties is no question is one of the main parts of the corporate governance, mainly because when this comes to corporate governance, it depends on the codes or guidelines made by the private institution. As an example, in Sri Lanka, there are so many codes made by the chartered institution. They are not comes by the parliament. So what's the difference between those codes and the laws? Other institutions have enacted codes and best practice standards to ensure that the companies are properly governed. So we have CSA rules. So these are some of the codes we have here in Sri Lanka. Right? Code of best practice. It is a product of Chartered Institute. Code of best practice on audit committees. Code of best practice on corporate governance. Right? So mergers code, good governance code, right? So there are so many CSA rules and regulations, right? So there are code practice and standards, but they have qualified by the private institution, not by the parliament. The difference is, if it is passed by the parliament, then it is a law, you have to come. But when they pass by those type of institutions, they are not laws, right? Therefore, there are no punishments. They have no right to punish the people. Sometimes they may take some action. As an example, if they don't follow the CSA rules and regulations, they can delist the company. But still they cannot punish them. Right? CSA rules follow them as a delist them, punish them. So therefore, that is right. But some countries it is okay because there are some countries like UK, those people are they really respect those practices. UK even though they break laws, they never will try to break that. Yeah. But your nation is business and politics. If I think very much they will need to some of them appeal need to not. Some of them have directors' duties are so important because when there's a breach of directors' duties, then you can take action because it's a law. But even though they break or don't follow those codes, then the law can do nothing because they are not passed by the parliament. Therefore, our people are also not such respected people who will respect those practices. So that is why the directors' duties are so important when it comes to the corporate governance in Sri Lanka. However, some of the laws have now become mandatory. Say, as an example, now there are some rules in that they are made by the CS, Colombo Stock Exchange, but it is also not law. But what they have done is now SEC Act has passed laws not to comply with those rules are considered as breach of Securities and Exchange Commission Act of Sri Lanka. Like mandatory. Some make a CSA rules for the minimum Samara SEC Act. So some of them are allowed. Now there is a mandatory requirement to have a non-executive day. And the commission should have a independent directors, either 2 directors or 1 directors of PSC. Should only consist of independent directors, whichever the high. Right? And also, salary committee, nominee committee, and audit committee should only consist of independent directors. Right? So those have now become mandatory, and also criteria for independence to be disclosed to annual data. So likewise, there are some mandatory requirements today. So that also should be respected. Right. So that is enough for the directors and their duties. So we will have a break, then we will discuss about the secretaries and auditors. Board of auditors and so board of secretaries. Secretary and hope to discuss with this 10-15 minutes, and then we will discuss about the auditors holding to be there, because you all hopefully are in fact to be auditors. Next. Still good, right? Okay, that was available. Practical biology, appearance, you have to discuss. Auditor can appear that all discuss again. When the lunch are used to be the and the later all discuss. Lama would have auditors I have great extra. We also discussed about the role of company secretary. After 2007, now auditors, accountants also act as company secretary. Some auditors office, they also do the secretarial work as well. So we discuss how secretaries are appointed, their qualification, and the change in role of the company secretary. As you all know, some formalities of companies are that companies should have director and secretary, right? And also they have to maintain the register of company directors and secretaries. So every company should have a secretary under section 221. And the companies which has more than 1 million turnover or more than 500,000 stated capital should have a qualified secretary and auditor. Right? If a company's turnover is 1 million and the stated capital is more than 500,000, such company should have a qualified secretary. In the PLC, it is a requirement, right? For the PLC, it is must to have a qualified secretary. But for the private company, right, any person can act as a secretary auditor, but again, if the turnover is more than 1 million, that means even less than 100,000 per month, right? So hopefully, I don't think that type of companies are there. So almost all the companies should have a qualified secretary. But as very first time when company incorporate, they don't mention it as a 500,000 or 1 million. Then initial companies, any person can act as a secretary only. So to act as a company secretary, they have to give their written consent. Secretary has to give their written consent to act as a company secretary. It is done by way of Form 19. Right. So that Form 19, there's a declaration that I agree to act as a company secretary of so and so company, and then that person has to sign and file. Right. So that's a Form 19. So who will appoint the secretary? Company secretary is appointed by the board or director of board. So we discussed about the qualification of directors. So to act as a company director, there was no requirement of formal academic or professional qualification. You can compare that with the qualification of a director. Right? Can foreigners act as a company director of Sri Lanka? Foreigners? Whether foreigners can act as a director of Sri Lanka? Okay. There's no issues. Foreigners can act as a director, they do. And this qualification people have to even they can be shareholders, but there are some ways to become a shareholder. They have to come through BOI. But to act as a director, even they don't need to come through BOI. Any person can act as a director. Sri Lankan citizen. Therefore, even the person can act as a director of a company. But for a secretary, only the Sri Lankan citizen can act as a company secretary, right? So, be a citizen of Sri Lanka is one main qualification. Only the Sri Lankan citizens can act as a company secretary. And they must be reside in Sri Lanka. Samanne Lanka Vivasa Interna, Lanka Pulgas Secretary. Sri Lankan citizens who already reside in Sri Lanka. Apart from that, there are some formal qualifications as well. So you can see they are recognized professional academic qualifications are required to act as a company secretary. So they have to be a lawyer. Attorney at law, that means the lawyer, or member of CE, or member of the Institute of Chartered Secretaries and Administrators in Sri Lanka. They are the most proper person to act as a company secretary. Right? So, or CIMA members, or secretary, assistant secretary, deputy secretary under the previous act. So those are the qualifications to act as a secretary of Sri Lanka. What can you see by looking at those qualifications? Probably only the professionals can act as a company secretary. But as a director, we know any person over 18 can act as a director of the company. But to act as a secretary, there is a requirement for some formal academic professional qualification. So before 1971, there were some issues about the role of company secretary. Especially there was one case that Barnes Force and Company versus South London Transfer, which is decided in 1887. In that case, English court decided that company secretaries are mere clerks. They are mere servants of the company. They have to do what the directors ask them to do. They cannot act themselves. So, at that time, company secretary was regarded as a mere clerk or servant of the company. And also, when you look at the very initial company law statutes, there was no qualification required to act as a company secretary. Any person could act as a company secretary. But that gradually changed. Now you just saw the requirement to act as a company secretary. Looking at those qualifications, can you think that they are mere clerk or servant anymore? Auditors, lawyers. No, we can't say that they are mere employees or clerk anymore, right? So that was changed with this second case, which is also the classic case in company law as well as in agency law. Panorama Development Limited versus Fidelis Furnishing Fabrics Limited. I'm sure you might have discussed this case under agency law in perspective to remember. Right. So in this case, the facts are like that. In this case, there was a company. The company had the secretary. This is in 1971. That time, that qualification was there. But we require today were also there by 1971. But it was not in agency. So, in this company, they entered into the agreement with the car rental company to hire some luxury cars supported on behalf of the company. Those cars were very expensive luxury cars. All the cars were Jaguars and Benzes. So, this agreement was entered into by second. But however, the majority of those cars were used by the secretary and his family. So when the car rental company asked for their rentals, the company argued that we have not authorized the company secretary to hire cars on behalf of the company. And also they were used by himself and his family members. Therefore, we won't pay. So car rental company filed a case against the company, Fabric Limited, but they argue that they won't pay, that they have not authorized the secretary to enter into such a. The question was, who was liable to pay the rent? Whether the secretary personally liable or company liable? Try to give me an answer under company law or under the agency law. If you remember the agency law, right? Agency law and if a third parties can reasonably believe that this man has the authority, then the principle is that. Agency law third party can then the principle is like. Only thing is that person should have authority to act. Agent should have authority to act as an agent. That authority may be expressed, may be implied, may be ostensible. Right? Expressed in the Pula, resolution passed for a company something in implied in the Pula, directors are implied, even that it may be appearance purpose. Like a penny a money terminated Pula. CEO can managing director, so it appears to a third party, they have authority. So, however, if they have authority, then the principle is liable. The what do you think here? Who is liable, company or secretary? Yes, secretary is liable. Company is liable. Company. So, why do you say secretary is liable?
Because we don't have the authority to take to that.
I think so. Secretary has no authority to take. So, what about the car rental company? You think they believe the secretary has no authority? That's what they should. Nowadays, what is the role of the company secretary? It depends on the powers of the company secretary today. We can blend some general powers and the powers on the companies. Companies acting as the director, which is the company secretary who certify the company document. If secretary certifies the company document, then any institution will accept. Sometimes some document, even though they are certified by the directors, the banks and some other institutions ask, we need this is certified by the company secretary. Right? Directors are certified by second certified. So anyone will accept the copies of the company as true if they are certified by the company secretary. Right? Directors are certified by the and also when it comes to the limited companies, not listed companies, they issue the share certificate. Share certificate on behalf of the company signed by who? Director and secretary. Director and secretary. Right? And also the other relationship between the company and the registrar of companies are generally done by the company secretary. And if company has a seat, it is in the hand of the company secretary. All the resolutions are written, minutes are taken by the company secretary. Right? Even though he cannot tell me in the meeting, it is the company secretary who makes all the arrangements for the board meetings and the company meetings, and also he acts as a secretary. And also, in many companies, it is the company secretary who advises the board of trade. In many companies today, company secretary acts as an advisor to the board of secretary, especially in legal matters. Right? And also nowadays, company secretaries, in fact, are considered as a chief administrative officer of the company. In some private companies, you won't see, but when you go to the proper companies, you will see that the whole any director, whoever, CEO, whatever they are, go and ask for the secretary. Right? So he will act like this, act as a chief administrative officer of the company. So that is the true role of the company secretary today. Right? Therefore, probably anyone will expect that such a person has the authority to enter into administrative type of contract. Right? Therefore, in this case, English court decided that it appears to the car rental company that the company secretary has the authority to sign a car rental company on behalf of them. Therefore, court decided he has acted as an agent, so company is fine. I think today it is not only appearance, it is implied. Right? At that time, it was decided it is an appearance authority. But today, I hope it is also implied that secretary has such authority. Right? Therefore, in this case, court decided the role of company secretary has been changed. Company secretaries are not mere employees or servants anymore. They are the chief administrative officer of the company. This is evidenced by their true role and also by looking at the Companies Act. If you look at the Companies Act 529, when they define the term, interpret the term officer, who are the officers of the company? It was not there in 1880, but in 1971, officer was defined as it is today. Right? Officer include what we are there. 529, interpretation section. Officer taking over in the
Director going overhead. Director manager.
yes, director, manager, secretary. Next, so even the Companies Act recognize company secretary as a company officer. Right? Therefore, if the Act recognize company secretary as a company officer, so the judges can say they are clerk or servant. Right? So company secretary is a company officer. Right? Officer include not even the auditors. Right? Auditors not officer, but secretary is considered as the office of the company. Right? Managing director, board of directors, and secretary are equally considered as company officers. Right? Therefore, today probably it is implied that company secretaries are not mere clerk and they are chief administrative officers and they can represent the company entering into the administrative country. But it doesn't say that they can enter into the trading contract, right? They will have a bank loan like that, right? So they can enter into the trading contract, but they can enter into the administrative contract. So today the secretary holds an administrative portion of the company and his main function is to carry out the direction of the board of directors. Secretary is usually not involved in the day-to-day management. So they don't involve in the day-to-day management, but sometimes they may. As an example, if you remember, under section 186, board can delegate some powers. Right? If the board has delegated some powers to the secretary, then they may be liable as directors and there may be some fiduciary duties towards the company. If the company has delegated some powers. Right? And secretary can enter into a contract and perform act on behalf of the company in the course of administration and implementation of the decision of the board. Therefore, definitions company secretary can enter into the administrative type of contract. Right? As an example, employment contract. Right? Maybe to lease out or rent a place, building. That type of contract can be entered into by a secretary. However, still, there's no, it is not implied that secretary can borrow money on behalf of the company. Simply, secretary cannot enter into the trading contract. It is in the hand of the board. And also by the company on trading contract. So strike a name of the register, right? He cannot strike off a name of a register. It can only be done on the advice of the board. Or even he cannot summon a general meeting. He will take all the action to call the meeting, but only on the advice of the board. Right. So these are some section of the Compliance Act about the role of the Compliance Secretary. A document or record of proceeding requiring authentication by the company can be signed by the secretary of the company. That is why many institutions ask their copies to be signed by the secretary. That is the law. Right? And certificate signed under the name of the company by the director and secretary of a company, the share certificate, they also signed by the director and secretary. So that's the role of company secretary. So accordingly, only Srilankans who have a fiscal qualification can act as a secretary of the company. In some private sector companies, probably, yes, some people say that there's no role, but that's not true. Right? That is because there are a number of private companies in this country, they even don't file the annual. Right? But if they have a proper business law, it is always advisable to have a proper secretary. They don't charge much, right? But in fact, there is a thing to do, and it is worth to have a secretary by paying 25,000 per year. But if they are proper contract secretaries, they do have things to do, and it's worth for the company to have a proper contract secretary. Therefore, if you have a private secretary or whatever, yes, I advise and recommend you to have a proper person as a contract secretary who has a good knowledge of contract. But what our people do is, as the requirement of attorney law, they are sending of the person to apply their company secretary. Our lawyers, whether you are there, whether they have knowledge or not. Some people even don't know how to open an account with the law firm. Right? But only because they will come, they don't know. The only thing they don't know is many people. The only thing they know is they know how to incorporate a company. So we discuss how to incorporate a company. That can be done by any company incorporation or offer. But there are so many roles as a secretary, right? To maintain registers, right? You just look at some private companies. 75% of companies, private companies have no proper register, right? If just register, if they register secretary and register, private company would not 75% company. Secretary is the name, they are not right. If you have a proper secretary, they will maintain it. It's not a simple thing now, right? If there are foreign shareholders, foreign directors, there are different other things that you have to have some knowledge of the BOI law and there's some other exchange control act and all. Without that, you can't act as a proper company. Right? They have to pass resolution and keep. There are companies that just pass resolutions and they don't have a incorporate. Right? But if there's a proper secretary, they will meet with all those secretaries. Even though you die or whatever, this company has a proper record. When you want to change it, they have proper record. There are so many companies that I have come across, when they want to change and all, no records are. Then we have to do them from the very beginning. Sometimes for 10, 12 years, we have to graduate and get them. Right? Well, the secretary can number incorporate some other people are there are transfer and secretary import if you have a proper secretary, good and get the maximum advantage and make sure that you are service. Someone charge to find right to drive. Moment secretary, me are free one. Masul design for get gun. A birthday. Right? He translating and money done take a dollar, then it's well issue can if doesn't get a dollar. Until I go down that, probably that's in a content. Right? If you put that, is it possible? These are proper secretariat. There are good people who run proper secretariat services, go to them and pay a decent money and get to a secretariat proper money. They will maintain all the research. Whenever there are issues, we have all the proper public secretariat to come. Sometimes we have a secretariat office name, some other those other public they will get. Private secretariat to run kill issue in the run faster. Okay. Well, we were the means Siasa to get back to Sugar. Siasa to get that decorative public motor Siasa to get back to. Right? You get the number, there is another kid that means you can make them. And then it's Siasa to get product but have come out. If you have a proper second, they will make. Yeah, I'm not going to take a couple of ideas and say, well, I'm so that 75% private business over the government. Right? Mukhe kare no se kate kare or the gate kare no it kare. He will not take. Amma lower what compare. People design they come to that. So how is that? See, right? So therefore, yes, take a proper person as a person. Pay decent money. It won't only around 25. But they will charge for separate for actually to make that person as a but it really works. Right. Okay, we also discussed about the other important office of the company, the office of the auditor. Hopefully, you all will become auditors for one day, and with some knowledge of law. Forensic auditors are also like of this kind. So try to become a forensic auditor, like with some knowledge of the law. To one unloading we could tell again. Become obedient forensic auditor. It is also very negative in this country because I know that there are lawyers, they don't know for accounts. There are accountants, they don't know the law. So that never will fix to it, right? So if we have proper people who have good knowledge of law and accounting, so probably we can minimize those issues in the country. So that is why centralized hospitals can work. Like if you have a big of law and commerce, you can go up to the top. Right? The only second to that can be the experience also. Second be might be in the money value and the research point. They have not the research point, they have a similar thing. Right? A middle single line on the one target, equal for second is the lower point. Take the one day, middle single is one after another, either like a lower point. You can get a like that. Means in the level of start and low and because they need people who know the low and cost. Auditors come in and well to the mainly what you don't understand, he has to be like a right? Because they have to don't have to deal with it, from other parts of the turn over. Someone will come and adopt the but if he has some knowledge, whether it's a good deed, whether it's a valid power of travel, then he can decide. But we can make a decide such a few person because we have no knowledge of it. They are still important to have such knowledge, even if you are an accountant auditor, it is still important to have some knowledge of law. Right? So accountant law is must that is the subject of your syllabus, but it is always good to have someone knowledge as right? As a banker, you have to have someone to right. Auditors क्यों हम yes yes. So these are the subtopics that we will discuss. Who is an auditor? How to appoint auditors? Partnership as auditors? Qualification? Their fees, their role, their duties, their rights, and some decided case. Auditor can take a role. Yes, what society expects from auditors, right? if I ask you to use one term, one word, what will you use? Independent. Exactly that's what I expect from you, right? So, but it is not known by many students, so even when right? Make class again, say, but ask the guy, and I have the active right? Right? They won't use that term independent. Right? But society law expect from auditors mainly nothing but independent. Right? I'm sure you would have seen the audit report, right? Now, audit report like that, audit report की only मतलब होगा independent audit report. So throughout this lesson, you will see law has positions to protect that independency throughout almost like all the sections. Right? The law tries its best to protect that independence of the law. But it is highly questionable in this country whether there are independent auditors. Right? Because it is not easy as I teach you or as you listen to me to be independent. Country like bank of country like Srilanka. Because we all are human. If your payments are not sufficient for your expenses, probably it is highly questionable whether you can make the independent. And they are practical two issues. Independence and independence are these are very independent. Take one main reason, right? Somebody got a term on it, look at the I'm not going to they want to pay the right? It's still less than 10,000 income. How can we justify some young people's labor for less than 10,000? I'm not asking to pay them 50,000, no 100,000, no. At least two. Yeah. Past they are not. The young people, they need to get just properly. They work out of the labor laws more than 8,000. Young people, they are meant to be enjoy their life. Also, this year, it's by a follow me. Other than also fair, they have not follow the back and the luck and the Lama. Where Donavera could it tell them? If they are after the husband, as well as how to do it, legal unethical. I do not know why these people don't understand because there are real issues about the moral obligation. Right? So they should be paid a decent salary, at least 30,000, 40,000 for their expenses. They clearly work more than 8,000. So those are issues. Part this message, at least think of that once you become over. Right? So the car will have they can then the full one now. They can the full one, right? They can come Mukadro, they can see unethical and illegal. Right? The other fair, there are a lot of India connection you have. Now, the and also it was given even 10 years ago. It was a well, it's not then I want to be again. I don't look at that. Then you have to have experience as a child. But the previous experience is as a child. Right? Then again to have a decent salary, you have to have some experience as a child. Right? Here, it's not how to get my last year, as well as the how to get my. It is highly questionable how can you maintain it. Right? Because at that time you are 28, 30, so you have dream, maybe you have family. Right? Then it's You can't maintain independence. And even though sometimes you say you want to be independent, ignoring all those things, even if you want to be independent, but it's still there. So you have not aware that police secretary, police independent managers somehow, it may be either moving in the system. No, true. Right? Or not like you, in the very good area, this is negative. That type of issues are also. And then another time of judgment they have to central policy. That could be the end of independence. Yes. I will die about the judgment there in a very central policy only that you yes, you know again. Yes. Well, that's it. I independent area. We'll be a very down other I will die of a silk. So that could be the industry. That is why I said, it is not easy as we discuss. But at least we should know, this is not to expect. Somehow because the people are very aware that judges should be independent. But society is not aware that auditors should be independent. Right? Judges are independent, auditors are independent. It is same rule, same thing, the law expects from judges and auditors to be independent. And also, these are the two sections of the society who can make the country a better place. Judges and auditors. But unfortunately, auditors' role is not socialized like judges. Judgment I am now local Lanka and auditors are but I have a society auditors not independent members. So they are another part of people, they can make a country independent, but unfortunately we still have no independent. Independent proposed persons are the 19th Amendment against Jumna, they get down a steps and CA is silent. They will look at the independent commission, audit commission is not we have question about independence, but at least it was not appointed. And also the authorized people are silent. They will leave center of Kalaman then and so we do need such a person. Right. So we'll see what provisions are there in the law to protect the independence of the auditors. So, auditor is a person who makes an independent report to a compliance member. So, basically, auditor is appointed by who? There are different ways to appoint us. Practically, basically, they are appointed by the board. Board is an appointment. But they make their report to who? They make their report to the chairman. So they are not responsible for the person who appointed. Right? They will be appointed by the board, company, legislature, and whoever, but their responsibility is for the member. Right? So they do not responsible for the person who appointed them, but they are responsible to the members of the company. So they make an independent report to the company's shareholders as to whether its financial statements have been properly prepared in accordance with the Companies Act and other relevant accounting and auditing standards. So the report must also say whether company's financial statement give a true and fair view of its affairs. So almost all the special business entities are required to have their accounts audited. So basically, auditors are appointed by the board, right? So auditors, the importance of auditors, if I say something about the importance of auditors, you all aware that regardless of the type of company, all companies should have audit. All type of companies, this must should have a audit. And if the company's turnover is more than 1 million and state capital is more than 500,000 again, such companies should have a qualified audit. And their responsibilities towards the members of the company, whoever appointed. So, the first auditors of the company probably appointed by the board of directors even before companies incorporated, right? So first auditor can be appointed by the board. But if the board does not appoint the director, the board basically they do, right? If they don't, then at the first AGM, the company can appoint a company. But by, right? However, if the board does not appoint, or even the company doesn't appoint, then it is must to have a auditor. Therefore, registrar general of companies has the authority to appoint a company auditor. Therefore, the company auditor may be appointed by board, by company, or by registrar general. But practically in 90% cases, he is appointed by the board. So then, once he is appointed, his appointment is valid for how many years? The auditor's appointment is valid only for one, right? This appointment is valid only until the next AGM, right? At the next AGM, if he was not replaced, not removed, not resigned, then there is a automatic reappointment for another year. But if he resign, remove, or replace, then another new auditor will act as a auditor of the company for another year. So that's the law, right? So an auditor of a company is appointed by the board of the company should be deemed to be reappointed at AGM of the company. Yes. If there's no removal, resignation, or replacement, remove right? Resign there is an automatic reappointment for another year. Who can act as auditor? As a director, who can act as a director? Can limited company act as a director? It is disqualification to be a corporate body to act as a director. So director, limited company can act as a director. Can firm act as a director? No, only individuals can act as a company director. Secretary. As a secretary, may be individual, may be firm, may be limited firm. So the secretary is the secretary. Right? Even the limited company can act as a company secretary. Auditor? Yes. Can individual act as auditor? Yes. Individual can act as auditor. Limited company? No. Firm? Can. So partnership can act as auditor, provided that all the partners have a prescribed qualification. Right? If all the partners are members of CA, then partnership can act as an auditor. So those are the qualifications to act as auditor. Who can act as a company auditor? Once you get this degree, applied accounting, first class, can you act as a company auditor? No. Why not? And then first class applied accounting. Still you can't act as auditor. Why? Hey, By the students of Dr. BSAA accounting cannot act as auditor. Can they? No. Why? Maybe the best faculty for accounting is Galle. Next, higher research for and all. Can they act as a company auditor? No one. Yes, only the members of PA can act as auditor. Why? I understand well. I applied accounting and a septic intermediate. I Japur accounting intermediate. I chartered field to run an intermediate. In the charter road, you run that thing on me. Maybe I professors of accounting. Why do you can act as auditor?
It's like qualification. Why
If they are academics, they are professionals. So, what's the difference? Huh? Almost all the accounting people have at least 2 years of internship. That's why there's no accounting degree without internship. Mulai pegawai dan apa yang persegina, pakar terdapat accounting nama itu 2 years internship ya timna, anik campus lagi. Sama berapa degree ke nanti, dekalo dekalo mau tu antara pahal internship terpakai betul. Kalau dia tidak internship, kisah. Amen. See, members of the council until the bed. And corporate programs, to be honest, you learn much more than the creative. So, like, class in a way, because they are masking with something else. They are masking with a very taking time. They are taking on the section, they are totally unnoticed. I was a Thomas Martha Potent. Right? There was a coaching knowledge. There is nothing more knowledge to this. It's not knowledge. Wherever you know, they take what I would like. Right? If we are young, what is the balance? There is nothing more. The low. Mask became what they are doing. That's a lot. It's a yam, are you going to make a low example? And take a mask, you get agency right to regulation here. Right to commission. There's nothing wrong at all. Agency for the commission. The way out of people. When they go to low regulation, it's a lower in a category good academic Karaman by the English category. Eight classes, we can take a lowest of Balia for the lowest of Ghana. After they are living in Aduba, the very thing, not Adu. It's a big gap. Members are made. It's a new sir, we will like another year. No, we are like that. Or another way. Now, they tell me, lowest like it will. I didn't realize, but I think market is actively active to figure out how to run it. It is some knowledge because it is not your knowledge or skills. But the thing is now, right? We are able to very much handle very. අපේ ළමයි කටට සම්බන්ධ උදාහරණයක් then personality skill के personality only the members of a recognized body can act as auditors of any kind, right? Only a members of a recognized professional body can act as a auditors of any kind. That is because being a members of that recognized professional body, they have some type of agreement, contract with that organization. With that, they have some responsibility. Being a member of CA, right? Then there is a contract between you and the CA. So then you are bound by some obligation, right? Like disclosure and so on, right? So if you breach or break that ethics, then that person body has the right to expel you from the membership. Right? So that is why only the members of that recognized body can act as auditor. If you don't comply with their ethics and their obligation, then that body has authority to expel you from the membership. If there's no such body, then people may do so many mistakes, unethical things, but there's no person to control. Right? As now there's a CA as a controlling body, you have obligation, you have ethics, right? You have to have a continued relationship with them. If you don't act within that ethics or professional ethics, then as a professional body, he has the right to expel you from the membership. Then you can act as a. So that is why only the members of a recognized professional body can act as a. That's the reason on the CA members can act. But there's nothing to do with this and knowledge. Right? Case are okay, ne? Even at some of this course, they are not make a relationship with the obligation that a person is that they are collected to one of the other CA membership. They do not. And also apart from that, there are so many other requirements. Make a main thing. He compared that when they are approached slow, okay, then they will make continuous learning, continuous speaking, and they will make sure that you have to renew your membership every year. So they make sure that you are updated. Right? It's some couple of them have to make that they go to rules and they have a just person to make them you aware. It's a think about it and walk up there. For the next membership will answer. Right? It's a non-organized person and Mokwas nothing made a paper, because they got it's not couple relationship every day you have to change your. So that is why all the members of the CA can act as the auditors of the right? Apart from that, again there is a list of disqualification. So the members of CA can act as well. So if you are not a member of CA, then you can't act as auditor. CA member is saying, no, I don't get it. You have to do for the other four subjects and get them. It's a case study, you are subject to get membership program. So in the board of directors, there may be chartered account. In the board of directors, there may be chartered account. Can they act as the auditor of the company? Why? If there's a board of director, if you want to be a auditor of their own company, so clearly they can maintain the independence. So that is why administrator, even though they are members of CA, they cannot act as a compliance auditor. Employees of the company, there may be so many employees, they are chartered account. But they cannot act as a auditor of their own company. Why again? Something, right? Then they again cannot maintain the independence. Yeah. So they cannot do it. Act like a Purama DNA. they try their best to maintain your independence. කොච්චර කෙරුවත් ඉතින් මිනිස්සුන් කියන්නේ නේද? උඹලට අහුවෙන්නේ බස් ටිකට් එක විතරයි. ඒලෙන් මිනිස් කියන්නේ විදු තියෙන ඒවා වෙන්නේ ඒ බස් ටිකට් එකයි බස් ටිකට් එකයි ඒව තමයි අල්ලන්නේ කියලා මිනිස්සු කියන්නේ මානන්තරේ කියන්නේ. ඔයකසත් අහුවෙන්නේ ඒවා කියන්නේ. If he is a partner or in the employment of a director or employee of the company. Director කෙනෙක්ට බෑ. Director ගේ හැරි employee ගේ හැරි partner කෙනෙක් ඉන්නවා. මෙයා company director කෙනෙක්, මෙයා CA කෙනෙක්, මෙයා රොල් එක වෙන්න බෑ නේ. හැබැයි මෙයාගේ partner CA. ඒක ඇත්තට හොඳ ඇත්තට යුස් කරන partner කෙනෙක් නේ. ඒක මෙයා wife වෙන්නත් පුළුවන්, boy වෙන්නත් පුළුවන්, girlfriend වෙන්නත් පුළුවන්. හැම එකම කවදාවත් partner කියලා. ඒක එයාටත් බෑනේ. ඇයි? Wife na home independent maintain right partner nam clear right it's a I must same thing ne cannot maintain the independence right director director partner employee employee partner right because they cannot maintain the independence ne ඒක හරියටම හරි clear එකක් දැන් නේ right then sometimes with the comparison of winding up or liquidation. The liquidator may be a chartered account, right? But company's liquidator cannot act as a company's auditor. Again, same reason. Then they cannot maintain the independence, right? If that person is a body corporate, that's why I said only individuals and firm can act as a auditor. To be a body corporate is a disqualification to act as auditor. So therefore, in Sri Lanka, body corporate limited company cannot act as a auditor of the company. So it is a law. Why do you think such a law? Because Sri Lanka it is a law, but in some countries it is not a law. But if you look at the popular audit firm, top 10 or top 100, you won't see any limited company. Except one or two. Right? Almost all the popular audit firms, ENY, KPMG, PwC, of course, limited company. Why body corporate are not popular as auditors? Exactly. Do you like to have yourself as a limited company? The unlimited liability that no interest, right? Okay, limited company, right? My liability 100,000. These two limited liability. The law believes that as a professional and consultant, their liability should not be big, right? They should, auditors especially law believe that their liability should not be limited and they should liable for their audit and account without any limit. Right? That should be expired even for their family members. Right? So it is serious, right? You cannot limit your liability. There's no limit for your liability as an accounts auditor. You are liable without any limit for the accounts audit you do. So it's the law and law expect from that the law will not limit your liability. Right? කිසිම සීමාවක් නැතුව තමක් දැන් වාක්‍යම ගන්න ඕන professionals, especially auditors. ඒක තමයි law එක අමුදා තියෙන්නේ limited company එකට බෑ. Right? And also that's the main reason තමයි මම හිතන්නේ company එකක් කැමති කියලා limited company එකක් consultant වලට කියන්නේ. That is why they are not popular. And also, I think there are some other reasons as an example, if it's a limited company, there are some disclosure requirements. But when you do it, there are some type of things you don't need to disclose. As a firm or individual, there's no such requirement, therefore, you don't need to disclose. The limited company, on the company said there are some requirements. And that's another reason. But main reason is the unlimited liability. or if he is not qualified to be appointed to act as auditor of a related company because of any other relationship preferred in the law. Right? ඔක්කොම කාර්ය වෙනත් එකක් දාලා තියෙනවානේ මොකක් කල relationship එකක් තියෙනවා auditor වෙන්න එපා. Because you cannot maintain the independence. Therefore, the law provides enough provisions to maintain the independence of the auditors, because that is what law expects, that auditors should be independent. What do you know about their fees? Auditors like fees, that depend on the escape. Only for some other lowest one, sometimes we never know. What is important is, that's the understanding. The lowest one here. All the professional taking it up time, low academic. This is the professor they can. They got some procedure plan to get on the office. However, this is the net of the they let us give them. But then some other say, no, I have 1 million next 1 million. But I will get some other, they will get advantages here. Advantages here. Only does that in them. Lanka, you know, only about 4 is the central or the comparative. So their charges are really high. So what is important? It is not. It doesn't matter whether it's 100,000 or 1 million. Right? It doesn't matter. But what is important is it must be fixed. Right? If 1 million, 2 million, 100,000 it must be fixed. Other months are minimum 100,000 again for the candidates. Minimum 100,000 again. The upper limit will be the upper limit will be that depends on the and all. Samani money just qualified minimum 100,000. But compared to IPP, I think it's very less. IPP legal that some other minimum 300. Again, I'm writing about it. I have now found the doctors and money can right. But I think 100% people get something. I think I want to go to the middle of the day. There's some other ideas now. Out to now and then 300,000 factors. It's a huge problem for the and I pay huge figures of the IP they put the all the data in the public, they are given in the public. Because the IP management can do that. In the video, that. So the IP were the video that that's the case in the 300,000. Public institution will not have lost. Up to the public that they are executive level the practical will not give you $200 take a public institution to 2%. Take a money, have a term, a marking word for the Gala in it. Right. So, what is important is it doesn't matter what is the amount, but it must be fixed. Why it should be fixed? Fixed and mobile. I decided to that's very important. There are similar provisions for the judges. Judges' remuneration and pension can be increased, cannot be decreased. Judges are, by fixed delays. They are very one, this is 8% salary, that is to maintain their independence. Hey, auditors like this karate. Really tell me that. Hey, personal responsibility. Exactly the way it is. Nothing but independent. Right? I independently well done to one. Magi Padi Aduthalai make a kilo, very dry make a kilo, buying paragraph. Now we were very good. Right? Now we were Aduthalai in a million grand or maybe by the store and Aduthalai back. So they can act, they can do account and audit without any fear of their salary. It is fixed. Right? So they can maintain their independence. So that is why their payment will not be fixed. I again return to where by Aduthalai or Indonesian that very regular not very Indonesian. Very clear there. It must be fixed. That is nothing but for maintaining the independence. Right? So it must be fixed and it can be decided by the person who appointed. If board appoint, the board will decide the fixed amount. If company appoint, the company will decide the fixed amount. If registrar grant appoint, then he will decide the fixed amount. Right. What is the role of a secretary? Independence. Right. They will very right? Are they employees or officers? Officers. Officer के लिए कितना जाएगा? So therefore they are not officers. They are employees. But they are not mean employees and you can compare with the original with other employees. Right? Because they are different type of dependent person. But probably employees, right? Labor loga some employees are even CEO is employee. So that's also employees. But sometimes we can exactly say if an auditor given an expert idea in prospectus or whatever, then they are considered as officers. For their expert advice, expert opinion, like whether it is another experts, then they are considered as officers. But basically, auditors are considered as employees, but they are clearly different from other employees. They are independent parties, independent firms. Because auditors are type of employees who can control the right powers of the directors are absent of that. But auditors are one type of people who can control the right powers of the Why compels lead auditors? It is a law. Sole proprietorship paper, you can have auditor, but it's not a law. In your partnership, you may have auditor, but it's not a law. But for a company, it is a law. Right? You have to have auditor. Why? A company auditors are must follow the law. In your sole proprietorship, it is your business, you run it. In your partnership, it is your business, you run it. But in company, it is your company, but someone else runs it. Right? Company's owners are shareholders, but it is managed and run by board of directors. So therefore, in some PXs, the owners do not know what they do. Right? Therefore, there's a clear gap between the management and the ownership. So that is why, to make this transparent, to make sure that they properly do it, to fill that gap, we need the auditor. If they are not independent, then there's no use of having auditor. So that is why they should be independent, right? To make transparent business, to minimize the gap between the management and the board. So that is why it is must for the company to have a auditor. If they are not independent, there's no use of having auditor for the company, right? Right. So, so this will check the account and account record of the company and prepare a report for the company's maintenance. So that's their main duty to prepare the audit report, right? So they have to make sure that the company's financial statements are properly kept, right? So it is a requirement that the companies have to prepare the financial statement. So the auditors will check whether their financial statements are kept according to the law, and they give a true meaning, and they help to prepare the audit report. And the report will say if the company's annual accounts have been properly prepared in accordance with the Companies Act and the other rules and regulations and accounting standards. The auditors will also consider if the information given in the director's report is consistent with the annual account, right? If in the auditor's opinion, the accounts of the director's report does not comply with the Companies Act, then the auditor will say that in their report. So those are some of the main duties of auditors. So it is obvious that their main duty is to prepare the audit report. They prepare audit report to whom? To the members of the company. We say members, ne? Shareholders, parents, limited companies, the company are not so members, right? So their main duty is to prepare the audit report. So the audit report how they it is a law. It's a Companies Act, right? If you don't comply, it is an offense, right? Companies are so audit report it's a law under section 156 of the Companies Act. Companies are required to prepare the audit. Audit report formal audit report right? So the auditor of a company shall make a report to the shareholders on the financial statement audited by him, right? So audit report it's a law, right? Audit report Companies Act, right? So auditor's report must contain the basis for opinion. Breach of Companies Act, right? Basis for the opinion, the scope and limitation of the audit, right? Whether the auditor has obtained all information and explanation that were required. So, never lost, right? Whether in the auditor's opinion, proper accounting records have been kept by the company, right? Whether in the auditor's opinion, the financial statement and any group financial statement given true and fair of the matters to which they relate, and if they do not, with aspect have they failed. Whether in the auditor's opinion, the financial statement and group financial statement combined in the requirement in the relevant section of the Companies Act. So all those requirements have been mentioned in the auditor's report because it is a law and requirement by under section 163 of the Companies Act. And under section 162, it's another duty of the auditor to avoid conflict of interest. An auditor of a company should, in carrying out the duties of an auditor under this act, ensure that his judgment is not impaired by reason of any relationship or interest in the company or any of its subsidiaries. So you have to mention that there's no conflict of interest. If there's any relationship, you should not audit that company's audit, right? If there's any type of relationship, you should not be the audit of that company. You might have seen in some cases, judges resign from sitting in some judge. Personal reasons, so on. Right? The reasons are there are some type of conflict of interest. So same thing applies to auditors as well. If there's any conflict of interest, you should not be the auditor of that company. And yes, also, we also discussed about the solvency test, right? So it's the duty of the directors to get that it is done, but it is done by the auditors. So solvency tests are carried out by the auditors. Another duty of the auditors to do a solvency test. What is solvency test? Only about a simple test. How you decide that the company is satisfied with solvency test? There are two parts. Equity test and the balance sheet test. Equity test is that company can pay its debts as they fall due. It has to be satisfied. And balance sheet test. Company's assets should be more than the stated capital and the liability. This company is satisfied with solvency. Okay, that's why we are doing it. Give a mark time for the solvency. Right? Okay, simple, isn't it? We have the assets, stated capital and liability. Right? Then you have to pay, you can pay the you can pay distribution. You can go for a major contract. Right? To all of them, you have to make sure that company is satisfied with solvency. What directors are running, right? Well, you are responsible for the corporate governance. Right? Inside of a partner and the against that. Auditors are part of the corporate governance. This is the yes, if you do this, the company will not satisfy the solvency, then you can't go. Right? So you should have that ability to get it done at any time, right? Panda solvency test can work at Panda here. That's a simple test. Right? And also, sometimes there are requirements to decide the fair value of the shares. Or maybe some matters of the company. When there's a requirement, say as an example, if there's a minority buy outside, then the company has to pay the amount of shares to that owner according to the fair value. Right? Then again, if there's a difference between the value asked by the owner and decided by the company, if there are differences, then the auditor will decide the fair value and that amount will be paid. So it is another duty of the auditor to decide the fair value of the shares or the assets of the company. So those are some of the main duties of an auditor. Right. Even though auditors are employees, they are clearly different type of employees. You cannot compare the auditors with other type of employees because of the special rights and duties they have, and they are given by the companies and by common. Right? So those are some of such rights of the company auditors. They have a right to access the company books and records at any time. Sometimes they are not available even for the owners of the company. Shareholders of the 8 to 4. The company has to give. Right? So they have access to the company records and books at any time. They don't have to give us anything. It's a special right of the auditor. Right? And right to get explanation from company staff. Right? They can be able also. So they can get explanation from the company staff, including the court of claim. Right? With or without cause. Right? Okay. Different types of officer, employee can give us, right? Owner can get explanation on one, including the court of claim. With or without. Owner will be a fact that they can go, owner will not do a fact that they can. Owner will do a right? Owner can go on, you will not have that. I'm not going to time on what you can take. Someone before the board can right? So I will give them I will start with like first money. Man can Satya Misa Satya non about it. Other number, Dura from the Kia. I'll cut them right? Only thing is that you have odds, you can life, you can the historical of the post. I think sorry, all that together. lowest customer. Again, we will do not have to tell prove the working. Even at that, the competition is it's a post bull market. Monthly, I don't know, for public employees, I don't know, public employees. Okay, because that time, that time, but we are president of the or public employees. Until we are take a another someone get the best. Kalau yang mula itu kita tundang kira mula kita kerana tu kuliah pasang kalau kuliah ini yang mana. उससे विधान करो हाली के फाइल करवाना है और जो इस तरह पावर करने का पेज दिलाती है एक मन और तीन दान देते हैं कभी एक दून नत्ता you are not a public employee एक आसान करते हैं नत्ता तासा वाला inside document के दिला ना होता है हम अपने ऊपर में करना के आप तो मेरा सारा हम पार्टी करना के ला जीवन भी ऐसा साजी से ले लेना ऐसा दून दान में ना कोई ऊपर में करना देगी Karena ada sertifikat putting in markets. Bila tak soal Islam ada tu banyak nikah. Kami cakap kita lama. Dosterlah, kita kan mana kita tahu kita jangan pakai mana. Pada kerana dan dosterlah ada kerana dia ini bandu knowledge. Exactly. Dikan kaya apa yang berada di dalam dalam itu bahaya begitu. Ini tapi panah berkerja. Kita tahu lagi apa pansi yang itu deh. Right? Itu boleh kisi kata apa ni? Nah tapi free kaya apa perlu ada dia. Dah pahen tunat ni. Nih. Ini kan tahu kan kertas dia pun nak mana dia nak berada. Colombo dalam mana jauh lagi tu Colombo bilawan. Kerana pun nak kita subjek itu sama kan? Insan yang mira, itu, awak Lanka sahaja terlebih. Apabila Lanka ni velven post, velven ni post kerana mana sama tu. Kalau Lanka sudah Indo, tapi itu sama lain dia mukut ni. Insan mira ni, jadi kalau dia public kerana kan dia tu, kaya kan mungkin kita tak akan dia. Dia nak ke awas ada berada dalamnya. Awas tu kita value kan ni. Okay, boleh dia awas payment ni. Lanka awas payment kita jalan dan kita payah jalan macam kita buat. Jadi orang hari itu ni pasti pun ni. Ini sampai pasti campur sama macam pada time buat. Itu pun pasti. Pasti boleh orang mampu. Attendant lagi ni India. Untuk mata saya kan, ni forward. Later. Sama apa ni? Nurse creator ada dalam pahat kita ini, mana? Pada anggaran boleh pahat itu kerana kita bisa uang awal sama kita. Ia tu tiada nama. Ini tak ni mandar apa yang kamu dia. Fokus di pada macam kira orang ni. Ani kita ni. Anda tu. Jadi pahat itu fashion ni. Dan dari itu saya buat anuak ini. Nah, macamnya kalau ada staff macam kira kalau kita pada itu ada ini. Boleh kira sebenarnya sama ani kan salah juga sebenarnya. Ini lah, sama ada benda tu apa? Sama ada kalau hektar itu benda itu tiada tu ke? Itu kalau hektar paling benar kalau tiada itu tak ada fashion ni. Bangun hidup lagi, aku tunggu yang kita pension, right? Mau spouse ka type ni pension, right? Ini dah orang pulang mana? අවුරුදු 75 කරන ආම්කාරයක විතර කරගත්තොත් 80 වගේ කරනවා තවත් තමයි. පැත්තට නෙවෙයි. ඒ අදහසින්ම වැඩි දෙන කටේ ගන්නවා. ගොඩාක් නෙවෙයි සමාජයක් තිබුණා. පබ්ලික් එක්ස්පර්ට්ස්ලා ඒකත් මම කෙනෙක් දෙන්න වෙන මොකද කරලා වෙන්නේ නැහැ. ස්පෞස් එකයි කොල කන්සර්න් නේ. ඒකත් නෙවෙයි. අවුරුදු නෑ. ඉස්සර අවුරුදු දෙකක් තුනක් පොඩ්ඩක් ගාන සලකලා කිව්වනේ. මම පස්සේ අපෝ ගාන යන කම්පැෂන් එක. ඔය විදිහට මේවා අමුතු පොඩි කරලා ඔය ගන්න නම් තමයි. කන්සර්න් නැති කරන්නේ. ප්‍රයිවට් කන්සර්න් කැම්පස් වල සෑහෙන නේද? මේ අපේ කැපිබිලිටි එක ඒ නිසා අපරමත පොඩ්ඩක් ඉතින් සාරි බලය අනුගමනය කරලා අන්තිම පුරා ගන්න. ඒ අන්තිමට අපි පස්සේ පරි සාපාරනවා. සීරියස් ප්ලෑන් $6 අපිට. ඒක පුදුමයි නේද? ඒ කපෝල ඉතින් තමයි අපට අපෝ. මොකටද මේ වගේ එකක් කරනවා? පොඩි දණක් කපන්න දුන්නාම අනන්තව කරක් නැහැ නේ. ඒ වගේ දෙයක් කරනවා. Right. Right to explanation from the company staff. It was say right to receive notice of general meeting. We have not yet done the company meetings. Then who is entitled to attend the company meeting? Directors, shareholders, able to come and company meeting. It is a informed. The auditor is not a director, auditor is not a member of the company. But he is also entitled to receive notice, attend the meetings, and even speak as such a meeting. So, special rights of auditor, right? Company meetings, so they are the company member. The auditor member can be, but he also entitled to receive notice, attend the meetings, and even speak at such a meeting. Only thing is he has no voting rights. All other rights are there. Right? And right to visit branches. I think it's also a responsibility, right? At least they should visit the main branches. And right to seek legal and technical advice. Auditors are also not expert in everything, right? In such a case, they can seek the legal and technical advice. For non-IT, lawyer, I have also given 2 times. KPMG is the monthly part of the appeal. They go to give explanation, give opinion that there is no pending case against this person. Police Manta has not pending case. Next, the main case compared the pending case of the area lawyer. Then what I do is I also go to the AGO. Now, when you file a case against the PHC, they have to file case through AGO. Right? Therefore, if there's any case, it should be there in the AGO. I have searched the document at the Attorney General office. For my opinion, there's no any pending case against this. So they have to know if $100,000 money is for that. That money is for that. So I think my opinion can be not do that. According to my opinion, there is no pending case. When a violence you should file a case against the company, you have to file a case to that. So we can check the file of that container, and if there's no pending case, then we can do that. Likewise, auditors are entitled to get technical and legal advice. Right? Right to claim remuneration. Take a common fight to come in. Right to refuse to comment story. But employees case but auditors even can refuse to start their work until they receive something or until they provide something. As auditor, you have a right to refuse to commence your audit. Right? And also right to question the board. Board question can try to qualify your report. Next. Right? Adverse, yes. Field. Then the adverse unfield gather not namagina the company one run. Area someone they a few months and that qualify field here in the book. Monkey and unfield gather. There must be some investigation. And also right of indemnity. if you have incurred any expenses, then you have a right of indemnity. Now, what's the time? Right. Some case law related to auditors, right? There's a different So Royal Mail is being better. If you are interested, when you have a lesson time, go through those cases, right? So it is this case. Before this case, audit report mentioned true and correct. After this case, it was decided that it is sufficient to mention the true and fair. Right? Make case in the current audit report true and correct. Make case in the true and correct true and fair make sufficient. Then done true and fair. We got a statement done by the judge about the role of auditor. We can give it in the color in color some of the auditors. So we're going to auditors again. Apart from we judge some case. We case judge statement they are coming again. Now we have already discussed about the director's duty of skill and care. It is not the same, but similar duty expect from auditors. They perform their duties as auditors. They also have to use their skill and care. They cannot be reckless or negligent. As a reasonable auditor, they have to use their skill, knowledge, and care. So that is expected from auditors as a similar duty of an auditor. Sorry, director. An auditor is not bound to be a detective. Auditors can rahas policy nahi. Agar ape kiyan bhujla thing anu policy ngai rahas policy right? They are not bound to be detectives. Right? Or as was said to approach his work with suspicion. Mum bhodu ke hita yan to nahi hame. Low level presumption of innocence. You can believe that those people are innocent, honest. Mum bhodu ke hita yan hame. Eme yan de ek rakata api bhodu. Right? Ye satama hai mein. That's why you should hold it. So those in this case judge says yes. Was said to approach his with suspicion. Suspicion again right? Inquiry mind suspicion mind right? Inquiry mind suspicious mind right? While inquiry mind so we need to second suspicious mind or with the foregone conclusion that there is something wrong. Book bodu, whether I want to ask you, He's a watchdog and not a bloodhound. Right? Apa kana ballo wenna onna muda ballo wenna thamai. Ek ආරක්ෂාකාරකමයි වෙන්නේ. පොළොවලට නිසු වෙන්න. He is justified in believing tribes servant of the company in whom confidence is placed by the company. Right? He is justified in believing tribes servant of the company that they are honest. As auditor, you can believe that the company employees are honest. මිනිස්සු ආවන්තයි අහිංසකයි හොඳයි කියලා හිතන කොහොමද ඒක කියලා දන්නේ නැහැ. ඉස්සරහට ගිහලා බලමු නේද? සමහර දුන්නාම they accept. අපේ වගේ මේ අරුගේ සීල් එකනේ අරුගේ ඇස් කරන්නේ නේ. මේ කම්පියුටර් කිල්ට අවුට් ඔබගේ දීලා අපත් කරන්නේ නේ. ඔක්කොම ආපහු right? So you can believe that they are honest. Right? Reasonable क्या है क्या करना ये तो प्रश्न आते हैं නේ. There are so many opportunities that you can check them online too. If you have a doubt. හැබැයි ඒව කරන්නේ මුං පොඩු කියලා ගිහලා සීල් එක දාන්න කියනවා ඒ කලින් සීල් දාන්න දැන් right when there is all the facilities for you to check them online නේ සමහරවිට ඉන්නවා when there's an original and photocopy in front of you you send it back to some other and some other people to get it certified right තමන් ඉස්සරහට original එක video කරන්නේ කොයි හරි ගිහලා සීල් එක you can trust people that they are honest and good. Right? We are